Our last panel is entitled, What Constitution? The Use of the Constitution to Frame Public Policy Debates. We have four very distinguished panelists that we'll hear from to add to the already number of very distinguished speakers we've heard from. First, we're going to hear from Douglas NeJaime, who is an associate professor of law at Loyola Law School in Los Angeles. He teaches in the areas of family law, law and sexuality, and legal ethics. His research focuses on law and social movements, cause lawyering, and sexual orientation discrimination. NeJaime's scholarship has appeared in the UCLA Law Review, the Iowa Law Review, and the Ohio State Law Journal, among many others. So, Professor NeJaime.
Thank you. I'm surprised that the room is not as full as it just was. I thought everyone was here for this final panel. But I want to congratulate those of you who have made it to the final panel, and I will not be offended if any of you fall asleep. And it's particularly difficult to go after such a great keynote address from Professor Balkin. I want to thank Professor Goldstein for inviting me, and Dean Logan for hosting us and the other participants of this conference, and also Chelsea Horn and Melanie Stone, who did a really tremendous job helping me with the logistics. I was asked to speak about frames around same-sex marriage, and so I'm going to talk about the constitutional framing of that issue and tie in, hopefully, a little bit to the more general discussions about popular constitutionalism that we've been having. So in 1999, the Vermont Supreme Court held that the denial of rights and benefits of marriage to same-sex couples violated the Vermont Constitution, and the legislature in 2000 enacted civil unions. LGBT rights advocates celebrated. The ACLU announced in a press release that, quote, Vermont now becomes the first state to require complete equality for same-sex relationships. Matt Coles, the ACLU LGBT director, said, the court says that in Vermont at least, lesbian and gay couples should get the same treatment the law gives to heterosexual couples. Whether you call that same-sex marriage, domestic partnership, or something else, it is full equality, and that's a historic first. Fast forward 5 years. In 2005, the New Jersey Supreme Court followed Vermont, and the legislature subsequently enacted civil unions. This time, LGBT rights advocates complained. David Buckle, who litigated the case for Lambda Legal, wrote that, quote, for the government to use the label civil union is a considered choice of language that assigns us to second-class status. He felt compelled to pose the question, does this mean Lambda Legal opposes civil unions in all instances? His answer, no. Whatever the calculus that defines the best strategy for an individual state, our role is not only to help get to success, but also to ensure that everyone knows it isn't over until same-sex couples can choose freely from the same range of options as different-sex couples. What changed in between these two events? How did civil unions move as both a constitutional and political matter from equality to inequality? Today, I want to argue that constitutional frames, and more specifically, LGBT rights advocates' ability to articulate, hone, and resolve those frames in court played a major role in this move. And not only did the constitutionalization of relationship recognition and the turn to courts facilitate the shift from equality to inequality in framing civil unions and domestic partnerships, but the quest for marriage on constitutional terms and through court-based tactics eventually required the reframing of civil unions and domestic partnerships as inequality. And the favorable environment in states with domestic partnership and civil unions made marriage advocacy more likely in those states, and thus centered the move to distinguish non-marital relationship recognition as inequality. Given the topic of today's symposium and the specific discussion of both how constitutional principles shape public discourse and in what venues those constitutional principles should be contested, I want to focus on how constitutional commitments structure the framing context over same-sex relationship recognition, and how social movement advocates themselves formulate, dispute, and resolve such frames through court-based tactics. We actually haven't talked very much about courts today. We've been talking a lot about constitutionalism outside the courts and popular interpretations of constitutionalism, and I want to sort of insert courts in a more positive sense into the discussion. By attending to courts, we can see how the remedy for the Vermont Supreme Court's equality mandate eventually became the injury of inequality that the courts, including most recently the Ninth Circuit panel, have recognized. I thought this was especially relevant to discuss in Rhode Island, where last year the state passed civil unions, and it really became the first state in which there was a concerted LGBT movement effort to oppose the law because it was only a half measure. And I read just this week that apparently only 46 couples have entered into civil unions in Rhode Island. The process I'm observing is one of frame transformation in which movement actors are changing earlier meetings and generating new understandings of the same concept. And I want to stop along 4 points to see how this happens. The first is the Vermont Supreme Court decision in 1999 and the legislative enactment of civil unions. The second is the Massachusetts Supreme Judicial Court decision in 2003 in Goodridge and the subsequent opinion clarifying that only full marriage rights would remedy the constitutional violation. The third is the New Jersey Supreme Court's 2005 decision in Lewis versus Harris and the subsequent passage of civil unions. And then finally, the Perry versus Brown litigation, earlier Perry versus Schwarzenegger, including the trial, the district court opinion, and the Ninth Circuit. By attending to a specific social movement context, we see that courts may be an essential part of the process of popular constitutional mobilizations. Popular constitutionalism often assumes that individuals have the capacity to articulate and influence constitutional norms without paying adequate attention to the processes of mobilization and the institutional structures that permit constitutional contestation. That's why Professor Balkin's intervention is so important. As he argues, individuals usually mobilize through movements, and these movements work very hard to gain traction for their constitutional visions, including through court-based strategies. So let's look at Vermont first, where in Baker versus State, LGBT rights lawyers argued that the Vermont Constitution's common benefits provision required that same-sex couples be given the same rights as married different-sex couples. Why did advocates turn to courts in Vermont instead of working through the state legislature? Subordinated groups rarely enjoy the type of access to publicity and mobilization that models of popular constitutionalism, and particularly iterations that turn away from courts, implicitly assume. Instead, as Professor Forbath suggested earlier in the day, these groups and the activists who represent them have to take organizing and mobilizing steps. They engage in collective action, they create important events, they access decision-making processes to gain publicity and attention to mobilize constituents and sympathizers. As work on popular constitutionalism shows, constitutional principles provide a common language with which groups can explain their grievances and articulate their demands, but these articulations aren't worth very much if no one's listening or taking them seriously, and courts provide venues for drawing attention to the constitutional frames. Courts are public, they provide access, they make decisions, they generate publicity, both through the process of litigation and through the act of adjudication. And in this context, courts from the very beginning provided the only state-level venues in which to make realistic claims for marriage. A few state legislatures were grappling with relationship recognition in the 1990s, but marriage wasn't really on the table, and it was courts that were forced to listen to the marriage claims and decide on such claims, thus forcing discussions of marriage in the legislative arena. Though the petitioners demanded the right to marry in Baker, the court decided that the constitutional violation could be remedied by giving the rights and benefits of marriage through a non-marital form to same-sex couples. In some ways, this followed logically, though not inevitably, from the common benefits framing of the case by LGBT rights lawyers. The state provision is the analog to the Equal Protection Clause in the federal Constitution, but the advocates really focused on the benefits language here and framed the claim as the exclusion of same-sex couples from a host of benefits given to married same-sex couples. In fact, very different than what you see in litigation today, the argument section of the plaintiff's opening brief at the Vermont Supreme Court focused heavily on, quote, the broad panoply of legal, economic, and social protections and supports for married couples and their families, while devoting a single sentence to, quote, the social value of state-recognized civil marriage. The legislature enacted civil unions, the country's first comprehensive relationship recognition system for same-sex couples, and equality through this lens was understood as material rather than dignitary equality. The frame, as resolved by the court, then sat out there for LGBT advocates to carry. They had a choice. They could seize on Justice Johnson's concurring and dissenting opinion, which faulted the majority for falling short of the full right to marry, or they could pick up the majority's decision and claim it as a victory and as giving full equality to same-sex couples, and they chose, for the most part, the latter. There was, of course, power in claiming victory. It mobilized constituents. It convinced elites to support the movement. And it also could lead to similar victories in other states, including states that had constitutional amendments and statutes that actually prohibited marriage recognition. So it's no accident that soon after Vermont, representative courts in California introduced a civil union bill, which ultimately led to the comprehensive domestic partnership law in California. Nonetheless, advocates didn't adopt this equality frame unthinkingly. They were in the background collecting evidence that civil unions actually perpetuated discrimination rather than granting full equality. And then a few years later in Massachusetts, they successfully argued that the Massachusetts Constitution required same-sex couples be treated the same as different-sex couples. The same lawyer, Mary Bonato from GLAAD in Boston, that argued in the Vermont litigation, argued the Massachusetts case. The legislature wanted to do Vermont-style civil unions. The Supreme Judicial Court said, no, you need to grant full equality. Bonato and her colleagues were able to rely on their experiences with civil unions in Vermont to articulate why civil unions actually wouldn't grant that full equality. They could show now that because of the cultural significance of marriage and the unfamiliar status of civil unions, the Vermont remedy didn't actually provide the equality that the Vermont Supreme Court said was guaranteed, and that influenced what happened in Massachusetts. In Massachusetts, by granting equality on marital terms, the court itself acted as a framing agent. The Massachusetts court influenced the debate and shaped the discussion, both in Massachusetts and around the country. In fact, Mary Bonato wrote a lengthy article after the events in Massachusetts in which she explained the way she actually picked up the Goodridge decision to get legislators on board to block a constitutional amendment, to portray opponents as trying to contravene announced constitutional rights. And so the decision in Goodridge really influenced the political debate. We see this facilitative role for courts much more fully when we look below the Supreme Court, and even when we look below the federal courts to observe what's happening in state courts and with state constitutions. When we take a more bottom-up approach to courts, we can move beyond questions of judicial supremacy and instead see that in many instances, courts move forward and shape constitutional dialogue rather than stunt or squelch such dialogue. Again, attention to state courts where state judges are commenting on constitutional commitments that reflect and constitute national commitments suggests that even when courts of last resort provide authoritative rulings, those rulings become additional components in an ongoing social movement conflict and in a political debate both in the state and across the country rather than ending that debate. So we move to New Jersey, where advocates again demand marriage licenses for same-sex couples. The Supreme Court of New Jersey splits 4-3, with the majority allowing civil unions and the dissent arguing that only full marriage would suffice. LGBT advocates recognize the material benefits that would flow to their constituents from the decision, but they also rejected the holding, arguing that the court failed to provide full equality. The court's decision, which mirrored that in Vermont, was used now for very different purposes and functioned very differently in the broader constitutional dialogue. Civil unions were now comprehensively framed as inequality, as half measures that perpetuated rather than remedied discrimination against same-sex couples. The move was made possible in part because of the Massachusetts court's earlier decision and the activism that it inspired around marriage. The new framing informed the debate in New Jersey, where advocates continued to push for marriage and established a, quote, civil union watch to document the discriminatory effects of civil unions. Lambda Legal publicized numerous instances of third parties discriminating against same-sex couples. They sued UPS for failing to provide employee benefits to civil union couples. And these instances of discrimination bolstered the inequality frame around civil unions and discredited the equality frame that had earlier defined them. The documentation of discrimination merged considerations of symbolic or cultural equality with considerations of tangible or material equality. A key move of advocates were to successfully show that the inequality frame around civil unions actually rises to the level of a constitutional violation. Again, the New Jersey Supreme Court's decision didn't authoritatively settle the debate. It didn't determine what equality means in New Jersey. We still see a push for legislative same-sex marriage in New Jersey just in the past couple of weeks. And Lambda Legal also recently went back to court arguing that civil unions violate both state and federal equal protection guarantees. And just 2 days ago, the Superior Court there reinstated the plaintiff's federal equal protection claim. It's also important to keep in mind the influence of the counter movement in this framing contest. So at the same time that LGBT advocates are pushing forward relationship recognition, you have social conservative activists passing statutes and constitutional amendments banning marriage for same-sex couples, and in some instances also banning non-marital recognition. And they challenge non-marital regimes as violating those statutes or constitutional amendments. So in California, for instance, LGBT advocates defended the domestic partnership law against a challenge that it contravened the state statute. And LGBT lawyers had to argue that the two were quite different. So in this sense, the counter-movement turned to courts, necessitated the arguments that denigrated non-marital relationship recognition and distanced it from marriage. The counter-movement strategy in this sense aided the LGBT movement's shift from equality to inequality frames. In determining that the domestic partnership law didn't violate Prop 22, the California Court of Appeals concluded that domestic partnership constituted a separate and inferior status. Okay, now in California, you actually get litigation around civil unions, or there it's called comprehensive domestic partnership, versus marriage. After Proposition 8 amended the California Constitution's Equal Protection Clause, you get the Perry litigation brought not by movement lawyers, but by Ted Olson and David Boies with the newly formed American Foundation for Equal Rights. And Judge Walker holds a trial in which the parties explore the distinction between domestic partnership and marriage. The lawyers put on experts, themselves important players in the movement, who connected the constitutional frames of equality and inequality to bigger arguments around the disciplines in which they work. And these experts had to carefully reframe domestic partnership as harmful by distinguishing the earlier equality-driven frames. So Dr. Ilan Meyer, who's a public health expert, testified that the exclusion of same-sex couples from marriage and the designation domestic partnership produces emotional and psychological harm that leads to what he terms minority stress. In discussing the difference between marriage and domestic partnership, as opposed to marriage and no relationship recognition, Meyer testified that, quote, "You're actually making a clearer statement of stigmatization when you have this dual system, because it's not only that you're denying them the marriage, you're also saying this marriage is highly valued, and therefore you cannot get that part. So we're giving you something that we're calling something else." By crediting the LGBT movement's frames and discrediting the counter-movement's frames, the court itself reshaped the conversation around marriage for same-sex couples. Just this month, the Ninth Circuit panel affirmed Walker's holding, doing so on extremely narrow grounds that makes central the distinction between domestic partnership and same-sex marriage. In the rehearing for en banc petition filed earlier this week, the Prop 8 proponents actually argue that the equality impulses of states, that is, to offer domestic partnership or civil unions, makes it more difficult to retain marriage as a different sex relationship. To them, that seems counterintuitive. This goes back to the idea that the environment is more favorable for marriage advocacy in states that have actually, at first, credited those equality frames around civil unions and domestic partnership. Now, more than 10 years after the Vermont Supreme Court validated the equality frames around relationship recognition, LGBT activists at both a legal and political matter have successfully framed civil unions and domestic partnership as inequality. Marriage is now the foil. And this move draws explicitly on constitutional frames. While legislative advocates routinely draw on constitutional norms of equality in framing debates over marriage equality, these norms were first articulated and continue to be honed and validated in courts. I know I'm out of time.
You need a minute.
Okay, so I just wanted to know that this has been a fairly optimistic account of the role that constitutional frames play in mobilizations and the role that courts can play. But there's also a significant conservatizing effect that we can see when we frame social movements around constitutional frames. Other scholars have noted that equality, for instance, as a framing mechanism can lead towards more assimilative priorities and can advantage movement moderates over movement radicals. So to me, it's not surprising that we see Ted Olson making the, quote, conservative case for gay marriage, arguing, quote, that the very idea of marriage is basic to recognition as equals in our society. Any status short of that is inferior, unjust, and unconstitutional. When we refuse to accord this status to gays and lesbians, we discourage them from forming the same relationships we encourage for others. And even more recently, Ken Mehlman, lobbying legislators in New Hampshire not to reverse marriage equality, ties constitutional values of equality to conservative goals of individual responsibility, normative family structures, a non-interventionist state, and marriage as a private welfare system. For Ken Mehlman, marriage for same-sex couples is consistent with welfare reform in the 90s, right? So this increasingly conservative frame around this one issue, marriage, and the use of constitutional frames in courts can also have a narrowing and moderating effect on the social movement's broader agenda. Thanks.
Thank you, Professor NeJaime. Before I introduce our next speaker, I should mention something that I perhaps should have been mentioning throughout the day. There are CLE materials that are available for this event online on the Law Review's, the Law School's website at www.law.rw.edu/Whose Constitution. I'm required to say that because in order to receive CLE credit, we must provide accompanying materials, and you are required to read them, or Jack Balkin is going to come and give you a test. So with that said, now that I've fulfilled my obligations there, our next speaker, Stephen Calabresi, is the class of 1940 professor of law at Northwestern School of Law, where he teaches federal courts, comparative law, and constitutional law, among other subjects. He co-founded the Federalist Society and serves as the chairman of the Society's board of directors. He served in the Reagan and first Bush administrations from 1985 to 1990 and advised Attorney General Edwin Meese III, Ronald Reagan's domestic policy chief T. Kenneth Cribb, and wrote speeches for former Vice President Dan Quayle. Since joining the Northwestern faculty in 1990, Professor Calabresi has published more than 30 articles and comments in law reviews. Professor Calabresi.
Thank you very much. My comments very much will try to build on what Professor Balkin said about the presidency and popular constitutionalism, and on what Professor NeJaime said about the courts and popular constitutionalism. And in doing this, I'm elaborating on an argument that I made 14 years ago in Law and Contemporary Problems. As Professor Balkin's keynote address reminds us, a key feature of the U.S. system of the separation of powers is the role that our presidents play in shaping the future of constitutional law, of the Supreme Court, and of the lower federal courts. Through his power of nomination and appointment, his power to shape the litigation policy of the United States, and his ability to propose constitutional amendments and new statutes, the president inevitably plays a central role in shaping the constitutional constraints that will confront his successors. In doing this, the president is the conveyor belt who transforms popular constitutionalism into Supreme Court doctrine and case law. And no account of popular constitutionalism, as Professor Balkin emphasized, can overlook the central role of the President of the United States. The Constitution-shaping role of the President, however, is somewhat ironic because Americans take great pride in the fact that ours is a government of laws and not of men, and that no one in our constitutional system, not even the President, is above the law. The fact that the President is simultaneously subject to constitutional law and is a maker of constitutional law inevitably creates a tension. Government lawyers, and particularly the Solicitor General of the United States, are the ones who are caught up in the tension created by the President's uncertain relationship with the Supreme Court. Over the last 20 years, scholars of that relationship have put forward at least 3 theories suggesting how government lawyers, like the SG, should resolve the President's and the Supreme Court's contrasting legal views. Departmentalists argue that government lawyers should take their lead from the President and should try to implement the constitutional vision of the President and those who voted for him. Other lawyers, who could be called court-oriented lawyers, argue that the government lawyers should take their lead from Supreme Court doctrine. And still others, such as Professor Tushnet's colleague, former Solicitor General Charles Fried, have argued that government lawyers should act as partially independent Burkean representatives elected by the President to try to represent him in the most favorable light before the court. My thesis is that the normative writing about the role of government lawyers is wrong because it assumes that all government lawyers play the same role at all times, and I doubt that happens. I think some executive branch lawyers always take on the role of presidential advocate, say particularly the heads of OLC or the White House counsel's office. Other government lawyers take on the Lincoln Kaplan role of Supreme Court-oriented conservative. This is often the case with solicitors general. And still others serve as ambassadors or middlemen between the two. The categories of pro-presidential advocate and court-oriented restraint lawyers are drawn from a book by Nancy Baker about different types of attorneys general, which I think is very revealing in the way that Professor Skoranik's work on the presidency is revealing. So I want to talk first about the relationship between the president and the Supreme Court, and then second about the role government lawyers play in making constitutional law. As I said at the outset, it's a core premise of our legal system that the president and his subordinates are subject to the same laws that bind ordinary citizens. The Constitution itself assumes as much, since it obligates the president to preserve, protect, and defend the Constitution, and to take care that the laws be faithfully executed. As Justice Jackson said in the steel seizure case, with all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law and that the law be made by parliamentary deliberations. President Richard Nixon, trying on Robert Frost's television show to justify his administration, once famously explained that if the president does something, that means it must by definition be legal. That view of presidential power was decisively rejected along with President Nixon. At the same time, however, as Professor Balkin's keynote reminds us, it is no less an axiom of our political system that, quote, no matter whether the Constitution follows the flag or not, the Supreme Court follows the election returns. And in particular, the Supreme Court and the lower federal courts follow presidential election returns. Professors Robert Dahl and Gerald Rosenberg have famously argued as much. The general public understands that presidents play an important role in changing the courts and the legal system, and I think for that reason, presidential elections always involve debate over legal and constitutional issues. President Barack Obama and Senator John McCain offered up very different theories of the role of judges in our last presidential election in 2008. Nor is this state of affairs with presidential candidates unique to the modern era. Abraham Lincoln, Franklin Roosevelt, Lyndon Johnson, Richard Nixon, and Ronald Reagan all ran for office in part by promising to make changes in the Supreme Court or in the overall legal system. Whatever the scope of a president's legal ambitions, he needs lawyers working for him to implement them. No president has the time and skill required to interview scores of judicial candidates, to draft amendments and statutes, executive orders, signing statements, or to edit or comment on the United States' briefs in the Supreme Court, or to shape the general law enforcement and litigation strategies of the federal government. The president relies on tens of thousands of lawyers in the Justice Department, in the U.S. Attorney's offices, in the Office of Legal Counsel, in the White House counsel's office, and in the legal advisors' offices of the various cabinet departments and agencies. Coordinating the activities of those lawyers is a very complex task. In particular, executive branch lawyers face two problems that I think differentiate them from lawyers in private practice. First, it's sometimes unclear to an executive branch lawyer exactly who the client is to whom they owe a duty of loyalty. If the lawyer is a political appointee, he will certainly have obligations to the United States government as a whole, but he may also feel an obligation to the president or presidential subordinate who appointed him and whose constitutional vision won the last election and which he's bound to reflect. Should a lawyer working for President Obama defend the Defense of Marriage Act, which defines marriage as the union of only one man or one woman? Should President Obama himself carry into execution the Defense of Marriage Act if he personally thinks it is unconstitutional, even though the Supreme Court has not yet said that? On the one hand, the president and his lawyers must take care that the laws be faithfully executed and the Defense of Marriage Act is a law. Presidents can't just suspend or dispense with laws on the books because they disagree with them. That's at the very core of what the Take Care Clause is all about. On the other hand, the Constitution itself is one of the laws which the president must take care to faithfully execute. If the president in good faith thinks the Defense of Marriage Act is unconstitutional, a position probably shared by 4 or 5 Supreme Court justices and by virtually all constitutional law professors, then why shouldn't he decline to enforce DOMA? In fact, couldn't an argument be made that a president who thought that DOMA was unconstitutional is duty-bound not to enforce it? Thomas Jefferson thought as much in 1801 when he declined to enforce the Sedition Act. A second problem facing executive branch lawyers, in addition to choosing between the United States and the president as their client, is that executive branch lawyers face complicated audience problems because they're usually trying to persuade many different audiences. For a practicing lawyer, the audience is usually a judge, a jury, or an appellate panel of 3 judges. In contrast, high-ranking government lawyers like the White House counsel or the Attorney General may have to worry about multiple audiences, including 1, the current and all future Supreme Courts, 2, the lower federal courts, 3, future historians, 4, the current general public and the media to the extent it covers legal issues, 5, the Senate, especially the Senate Judiciary Committee through which all nominations must pass, 6, the House of Representatives and its Judiciary Committee, which has the power of impeachment, and finally, the other executive branch lawyers who may or may not agree with the relevant legal agenda of the president. Lawyers in administrations like President Obama's with ambitious legal agendas, and I think I would disagree here with Professor Balkin and would say I do think President Obama has an ambitious legal agenda, will face an especially complicated audience problem. They'll have to endure short-term defeats, especially in the courts, while trying to persuade the general public, the Senate, and ultimately future historians and constitutional scholars. Such a long-term project requires bold speeches, briefs, proposals for amendments or statutes, and other things that will frighten and anger the courts. Persuading the courts and the ABA calls for painting in pale pastels, but persuading future generations requires painting in bold primary colors. The audience problems inhere in the job that any executive branch lawyer must perform because the executive branch can't write off any of the audiences that it's obligated to persuade. Every president wants to win over future Supreme Courts, but no president can afford to lose all of their cases currently that are pending before the federal courts. As a result, presidents need to pay attention to both sets of audiences. Presidents must have both a core legal agenda and a variety of fallback positions, and these different agendas must to some extent be communicated to different audiences at the same time and in public. One tool that presidents have for accomplishing this task is appointing different kinds of lawyers to different kinds of legal jobs in their administration. Cautious advocates of the Lincoln Kaplan mold might be charged with writing briefs for the Supreme Court, while bolder lawyers might be recruited to work on judicial selection or write speeches about constitutional theory. I believe this was very much the approach that Ed Meese followed as Ronald Reagan's Attorney General. Meese put young originalist conservatives in charge of writing speeches for him and judicial selection, but he hired as Solicitor General a non-originalist law professor, Charles Freed, who would be able to play a more effective role in appealing to a Supreme Court which had 8 members who were not very sympathetic to the originalist agenda of the Reagan administration. I think it's inevitable that there will in the executive branch be both types of lawyers, both presidential advocates and court-oriented conservatives, and the more ambitious a legal agenda an administration has, the more likely it is that there will be both types of lawyers. Particularly early on in an administration, when the Supreme Court may be very different in its outlook from the president with respect to constitutional issues, it may be very important to have some lawyers who can serve as ambassadors to that Supreme Court, like Charles Fried, and other lawyers who are writing for future Supreme Courts and for future generations of Americans. I think just to conclude, I think that the normative writing by departmentalists, and on the one hand, and by Lincoln Kaplan on the other, that executive branch lawyers should always take their cue from the president, or that they should always take their cue from the Supreme Court, is mistaken. I think that the set of incentives that the president faces inherently make it unlikely that the president will pursue that type of agenda, and so I think that it's inevitable that we will end up with some executive branch lawyers who are arguing the president's legal vision and others who are defending the court's legal vision. I want to conclude by just saying one word in support of the notion of popular constitutionalism, building on Professor Balkin's remarks. And that is, it's common for lawyers when hearing about popular constitutionalism to get their hackles up and to worry a great deal about judicial independence. And judicial independence is a very important value and a very central value, but it's not the only value that the Constitution tries to protect vis-a-vis judicial review in the courts. If one really wanted to maximize judicial independence, one might allow Supreme Court justices to elect their own successors. In India and in Israel, Supreme Court justices do play a role in electing their own successors. I submit that that is an absolutely terrible idea. I think it is vitally important that there be change on the court and that the court, in an indirect way and over a long period of time, be accountable as well as independent. And I would argue that the need for a Supreme Court that's both independent and accountable is also present in the executive branch. We need presidents who follow the law, but who also try in an ambitious way to be prudent shapers of the constitutional law that is to come. Thanks.
Thank you, Professor Calabresi. Our next speaker is Professor, no, it's Carl, then, sorry, really? Unless you really want to go first. Well, next speaker is Professor Carl Bogus, who is a professor of law at Roger Williams University School of Law, where he has achieved national prominence in two areas: tort law, and especially products liability, and gun control, including issues involving the Second Amendment. His work in the first area includes the book, Why Lawsuits Are Good for America: Discipline, Democracy, Big Business, and the Common Law. His writing on both of these subjects and others have been published by law reviews as well as opinion journals such as The Nation and The American Prospect. And one of his other interests is how ideology influences the law, and in that vein, he is the author of a biography, William F. Buckley, Jr., and the Rise of American Conservatism, which was published last year. Professor Bogus.
Thank you, Jaron. You know, it's always a novice teacher's mistake to tell their class, this is the first time I've taught this subject, or something along those lines, because they lose them immediately. Nevertheless, I'll take the risk with you by telling you that there is nobody that you've heard from today who knows less about popular constitutionalism than I do. In fact, I haven't written about it. If you listened to Jared's very nice intro, didn't mention anything that's related to popular constitutionalism. And so I was kind of wrestling with, as I was wrestling with how to make a contribution to this symposium, it occurred to me that actually I've been involved personally in a rather major way with two popular constitutional movements, one here in Rhode Island, one nationally. The one in Rhode Island, I was on the winning side, and that's what I'm going to talk about in a minute. And the one nationally had to do with changing how people thought of the Second Amendment from a collective rights view to an individual rights view. And in both of these instances, I sat on the board of directors of the advocacy groups, which were the leading advocacy groups either pushing or resisting these popular constitutional movements, and was kind of, inside the room, in some instances, one of the people calling the shots on these things. So I was wrestling with which story to tell you, to try to do both, and I only decided during Jack Balkin's talk when he got to the guarantee clause, and I decided to do the Rhode Island story. And those of you who are from Rhode Island, this may be familiar, except some of the little inside stuff that's never been told before. But those of you who are not from Rhode Island, I am reasonably confident you have not heard this story. And at the risk of being self-focused, I think it'll be most interesting if I just tell it in the first person. And so this is going to tell a story in the first person. I'm going to leave out the theory. You can relate it to the theories you heard earlier, but it's a pretty interesting story. And from my point of view, the story begins in 1996 when I come home. I was born and raised in this area, but hadn't been in this area since graduating from college. And I came home to this area to join the faculty of Roger Williams Law School. And my wife, who's also a lawyer, I think was the first one to tell me, she says, do you know that in Rhode Island, they don't accept the principle that there is separation of powers among the three branches of government? I said, that can't be right. That's not possible. You've got that wrong. And whenever I tell my wife she has something wrong, it's always a mistake. And I don't have the time to tell you the rich and colorful story of why that is, and the battles that took place over the centuries about this, but I can tell you that it does have a very interesting story. Madison mentions it in Federalist 47 when he says the Rhode Island Constitution was written before the doctrine of separation of powers came to the attention of the American founders. And for a whole variety of interesting reasons, Rhode Island didn't rewrite their constitution and operated under that constitution for really to 1840 when there was a revolution, the Dorr Revolution. And the Dorr Revolution was very much in part about attempting to have separation of powers. What happened is the legislature claimed to be omnipotent. And the Dorr Rebellion is a fascinating story. Can't tell it, don't have time to tell it, but the Constitution was rewritten in a way that was deliberately ambiguous. And time marched on. And now I come to 1996 when I came back here, and the legislature was taking the position that they were omnipotent, and among the things they could do, not only could they form an administrative agency and provide the administrative agency with its authority and its budget and conduct oversight, but they could operate the agency. Actually quite directly by appointing themselves, their spouses, their friends, and others to the boards that controlled the agency. And of course they did this with the agencies like in Rhode Island, where's the money? The Coastal Resources Management Council, and gambling, potentially anyway, the Lottery Commission. among the agencies they controlled. And they formed lots of agencies because it gave them lots of power. And Rhode Island had more agencies, still probably does, more agencies than the federal government, over 400 administrative agencies. So when I had arrived, one of the largest good government group in Rhode Island, Common Cause, in Rhode Island, Common Cause is a large, powerful organization, 2,400 members, had already been 2 years into an effort to bring the doctrine of separation of powers to Rhode Island. And the inaugural issue of the Roger Williams Law Review, Volume 1, page 1, starts with an article by Senator Sheldon Whitehouse, then U.S. Attorney, arguing that this claim of omnipotence by the legislature was very, very problematic, and separation of powers had to come to Rhode Island. The first thing that Common Cause did was to take this claim to the Rhode Island Supreme Court and said, of course we have separation of powers. Of course we have separation of powers. The powers are distributed into 3 departments, and that implies that they're separate, distinct, co-equal branches. We have the Republican Guarantee Clause that says that the United States shall guarantee a Republican form of government to the states. And what is a Republican form of government? This is the argument we started to make before the courts and then ultimately to the public. What is a Republican form of government? Or as Professor Foley would say, what makes America America? And we argued, well, maybe the 2 most fundamental things are the vote, it's a democracy, it's a vote, and separation of powers, because the vote and separation of powers being as fundamental. It's not America if a state says we elect a czar or a politburo. And that was our argument. And, among the many things we quoted, my argument, by the way, I want to make the point here, is we weren't really arguing to the Rhode Island Supreme Court, this is how you should interpret the Rhode Island Constitution. We were arguing, this is un-American. This is unconstitutional from the federal Constitution, Republican Guarantee Clause. So we did argue it was unconstitutional from Rhode Island Constitution, but that wasn't the important thing. We weren't saying, you got to listen to Thomas Dorr. We said, you got to listen to James Madison. Here's probably the most famous language from all of the Federalist Papers. If angels were to govern men, Madison, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable a government to control the governed, and in the next place oblige it to control itself. Ambition must be made to counteract ambition. There has to be checks and balances, and there has to be separation of powers. Or, as Lord Acton would say, power corrupts, and absolute power corrupts absolutely. And for a variety of reasons, power was more consolidated in Rhode Island than in any other place in America. Really only a one-party system. Only 16% of the General Assembly was Republican. Not really a bicameral legislature, although it was in theory. And that was because, for very strange reasons, the House consented to an internal committee which controls everything within the General Assembly. Who gets staff, who gets a computer, who gets an office, who gets a parking space. Let me tell you, in Rhode Island, this is more important than angels and ambition. And that internal committee was composed of 3 House members and 2 Senate members. The House members outvoted the Senate members. If you were a member of the Senate, and if you were a Senate committee, and you wanted a budget, you wanted staff, you wanted a computer, you went to the Speaker of the House. He was close to the czar in Rhode Island. And we said to the Rhode Island Supreme Court, this can't be. And the Rhode Island Supreme Court said, oh, but it is. They said, Rhode Island, I'm not making this up. 2 cases, 1999 and 2000. Rhode Island doesn't have the same system of government as the United States or the other 49 states. Its system of government, its phrase, is quintessential parliamentary supremacy. Now, I got to tell you, I don't think they understand parliamentary system, where there is separation of powers, although in a different form. But they just had the idea Parliament can do everything. And they said there are not 3 co-equal branches of government in Rhode Island. There's 2. There's the legislature, there are the courts, and their phrase, a diminutive governor. Now, then we launched a campaign to amend the Constitution. There was, I'm not going to get into the details of doing this quickly. As a practical matter, it required legislative approval. So here's a little inside story. Never told before. You're the first ones to hear it, although I won't reveal the people involved except for me and the executive director of Common Cause. We went to one of the leading citizens of Rhode Island, who I'm not going to identify. And we said, we're going to launch this very difficult campaign, and we need your support. We'd like your name, and we'd like your money. And he said, well, sounds pretty important. I'm going to call in knowledgeable political people, people knowledgeable about Rhode Island politics, and I want you to make your pitch to them, and I want to hear what they have to say. So we had a very nice dinner, and he had assembled a cast of some of the savviest people in Rhode Island politics, and there was no question that everybody thought the savviest was one particular individual who sat kind of at the head of a U-shaped table. He was the savviest political operative in Rhode Island. And it sounds like I'm being facetious. I'm not. He was the savviest. And so we made our pitch and explained why we thought we could pull this off. And then this distinguished citizen says, let's go around the table and hear what you guys think. So everybody up until the center of the table was hedging my bets on. I'm not, what I'm saying is ambiguous. I can't really tell what I'm saying. And then we get to the guy at the head of the table, and he says, look, this is doomed to failure. You cannot change the Constitution, as these guys have just told you, without legislative consent. This is the greatest source of legislative power, or among the greatest sources of legislative power in Rhode Island, and corrupt power. And they're making a lot of money at it. Some of it legal, some of it below the table. They're not giving this up. There's only one way you could possibly win this. And you would have to create such a firestorm that citizens of Rhode Island would have to say, if you don't vote for a constitutional amendment on separation of powers, we're voting you out of office. And he said, do you think voters are going to get riled? There's going to be a firestorm about some abstract principle of political theory? Voters are interested in taxes. They're interested in schools. They're interested in pensions and police. They're, in potholes. You guys think this abstract political theory is important. The people won't. Now, I think the key thing about this story, which I've already told you, I've already foreshadowed the denouement by telling you it was ultimately successful, is that it was a 10-year campaign. Started in '94, ended in 2004. And this is pretty important. It's very unusual, quite different from the gun control story in some ways. An advocacy group, to have members and to have contributions, has to show its members that they're winning things, that they're accomplishing things. They have to go to their membership every year. You can't, so you have to come up with something to win this year. Common Cause of Rhode Island said, this is going to be our flagship proposal until we get this damn thing accomplished. This is the most important thing in the state, and we're just going to stay at it forever. And every year, they had to go back, basically, to their members and say, we're still unsuccessful. There were other good government groups, and they joined the bandwagon, but then stopped really being part of this effort. But perseverance in changing public opinion turns out to be critical, and you got to stay with it. You know, it was kind of like, we're going to do this or bust. So, I've written this up, and I looked at this, and I'm not sure where I made a mistake in this footnote or not. But my footnote tells me that in the last 6 months of the campaign, and here's where I think it's wrong. I think it's not the last 6 months. I think it was the 9 years leading up to this. It had to be. But either way, there were over like 700, very close to 800, over 790 news articles, op-eds, letters to the editor in the Providence Journal on this topic. That's pretty amazing on this abstract concept. Now, I tried to get, one of the things we wanted to do was place a full-page ad in the, how much time do I have, Jared?
4 minutes.
One of the things I wanted to do was place a full-place ad in the Providence Journal, signed by 40 professors of political science and history and law, saying, you know, this is really important. And I collected 16 signatures from my colleagues on this faculty, like overnight. And I didn't expect to get too many signatures from faculty on the public colleges for reasons that are just all too obvious. But there are 7 private universities in this state. I remember talking to a political science professor at Brown. Would you sign this thing saying separation of powers is important? My field is international relations. Well, I mean, you went to like high school, right? You took civics. She said, separation of powers is complicated. I said, you bet it's complicated. The details are complicated. As a principle, don't you agree it's one of the 2 most fundamental things? I couldn't get 40 signatures. Couldn't get 40 signatures. Now, I'm low on time. And let me just say, we went and this was, you know, if you want to call it the elites, call it the elites. So the Board of Common Cause was made up of elites within the state. But we went out and in a kind of a cascading down feature, attempted to educate the public. And we went out and spoke everywhere. You know, the Rotary Club would hear us, the Kiwanis Club would hear us, the church would hear us. I think I wrote myself 8 op-eds for the Providence Journal. Ultimately, we formed what we would today call a super PAC, a separate organization, since Common Cause couldn't do it, to raise money and take out ads against members of the General Assembly who weren't supporting it. And we turned a lot out of the legislature. Now, here's the amazing thing, and this may be the most important lesson here for popular constitutionalism, in this story anyway. The distinguished political scientist at Brown, specializing in international relations, and her colleagues at Brown and Rhode Island College and Providence College and the other institutions in the state, may not have gotten this, but the people got it. They understood it just as well as they understand potholes and taxes. I don't have time to tell you how, move it all the way to the crescendo and the opportunities that came up and presented themselves, and the Monica Lewinsky-like scandal that had led to a perfect storm at the end. When the Speaker of the House had his Monica Lewinsky moment, and it turned out that people throughout all three, well, at least through two branches of government, including the executive branch, without telling the diminutive governor about it, did stuff to cover up this scandal. And the people understood about consolidation of power. And they understood it to such a point that 1 week, talk radio was on fire with this. There was no other topic for a week, wall-to-wall separation of powers. There were so many emails to the General Assembly, their system crashed. I have no doubt that had it been a secret ballot, there would not have been a referendum ultimately put to the people on amending the Constitution. But it wasn't a secret ballot, and it happened. And in 2004, the Constitution was amended, really against the will of the powerful forces in the state, and at the behest of a mob whipped up by elites. Thank you.
Thank you, Professor Bogus. It's pretty good for a first-timer. We'll now hear from Ilya Somin, who is an associate professor of law at George Mason University School of Law. His research focuses on constitutional law, property law, and the study of popular political participation and its implications for constitutional democracy. Somin currently serves as co-editor of the Supreme Court Economic Review, one of the country's top-rated law and economics journals. His work has appeared in numerous scholarly journals, including the where's my continuation page when I need it? The various important journals, like big ones, the very important ones, all right. And so without further ado then, Ilya Somin, I'm sure there was more good things to say about Ilya, who's a very impressive person. Let's hear what you have.
So I'm going to skip over the remaining parts of my bio that Jared didn't read because I hope that my talk will be at least slightly more interesting than they are. I'm also conscious that I'm the last person standing between you and your COE credits and your general enjoyment of the weekend, so I will try to be brief, although when a law professor says that, they're rarely telling the truth. However, I will make at least some effort in that direction. I will have a rational basis for that effort, enough of an effort to qualify to meet that test. So if there's one thing you've learned from this conference, it's that popular constitutionalism is actually popular. It's certainly popular within legal academia. It's one of the most talked about subjects in constitutional law of the last 15 years. And it's popular in the sense that a lot of people are currently trying to do it. Obviously, the Tea Party movement, already discussed at this conference, is an example of a popular constitutionalist movement. I think actually the Occupy Wall Street movement has also developed some degree of a popular constitutionalist dimension with their recent Occupy the Courts Day, where they had a series of demonstrations and events focused on the idea that corporations are not people and therefore, in their view, are not entitled to any constitutional rights. So unfortunately, however, I think there's been one aspect, or at least one very important aspect of popular constitutionalism, which is neglected in most of the literature on the subject, namely the question of whether actually the public has adequate knowledge of the constitutional issues that these popular constitutionalist theories suggest that the public should either decide exclusively or at the very least should have a much bigger role in deciding. Now, obviously, there are different popular constitutionalist theories out there. The most ambitious, put forward by people like Larry Kramer, the dean of Stanford Law School, suggests that the people should actually have the final say on virtually all constitutional issues, that the institution of judicial review should actually be overridden by popular control. More modest theories suggest merely that the public should have a bigger say in constitutional issues than perhaps it does at present. I think the problem of political ignorance is a more serious problem for the more ambitious theories, but it can be a potential issue for the more moderate ones as well. As a general rule, the more constitutional issues you want the public to decide and control, the more knowledge they're going to have in order to carry out that task in a successful way. So in the next part of my presentation, I'm going to talk briefly about the state of public knowledge of constitutional issues, which overall is not very good. Then I'll go on and discuss how that has some negative implications for popular constitutionalism. Finally, I'll conclude by saying that the existence of widespread public ignorance doesn't necessarily suggest that the public should have no role in constitutional issues at all, that they should be entirely left to the lawyers or other legal elites, but it does suggest that that role might be more limited, ideally, than popular constitutionalist theories would sometimes suggest. So first, speaking about public ignorance of the Constitution, overall it is not a pretty picture. Even very basic facts about the Constitution are often unknown to the large majority of the public. For example, a 2006 Zogby poll showed that 58% of the public cannot name the three branches of the federal government: executive, legislative, and judicial. More recent survey finds that only 28% can name two or more of the rights protected by the First Amendment. Similarly, a survey conducted by researchers at Columbia University found that only 31% of the public realized that the following Karl Marx quote is not actually in the Constitution, the one where Marx said, from each according to his needs, to each according to his ability. This may be an attractive principle to some, but it is not in the Constitution. Only 31% of the public, at least in this study, recognize that is not the case. Now, I could go on and give many more examples like this, but the overwhelming weight of evidence clearly does suggest that public knowledge, at least on most constitutional issues, is generally quite low. And it's not just that they don't know some very in-depth theoretical points that only experts could be expected to know. In many cases, they don't know even very basic things. I would note also that this public ignorance about constitutional issues is part of a broader pattern of public ignorance about political issues in general. And once again, I could give you dozens of examples. In fact, I'm writing a book where I do just that. Here I'll note just a few recent ones. For instance, the 2010 election, our most recent national election, was obviously hotly contested and very much in the news. But in the immediate aftermath of that election, only 46% of the public knew that the Republicans had taken control of the House of Representatives, but not the Senate, which of course was the result of the election. Similarly, although the state of the economy was the most hotly contested issue in that election, still over 60% of the public in a poll taken just before the election knew that the economy had actually grown rather than shrunk in the year before the election. And obviously one would think that it'd be useful to know what is actually going on in the economy if you believe, as the vast majority of the public said that they did at the time, that the state of the economy is the most important issue determining how you want to vote. Another example from 2009, when you may remember that Congress was debating the president's, or rather the Democratic leadership's cap and trade policy proposal. A survey conducted at that time found that only 24% knew that the cap and trade proposal was an environmental policy measure. More people than that thought that it was a financial regulation of some sort. And again, I could probably regale you with these sorts of examples for a long time, but the point is clear that the state of public knowledge of constitutional issues and also many other policy issues is overall quite low. Now, it is important to recognize that this deep public ignorance is not a recent phenomenon. It's not a result of the X generation playing video games or whatnot, not paying attention to politics to a greater extent than their predecessors. For as long as we have had modern public opinion data going back to the 1930s, we've generally seen a pretty low level of public knowledge. Indeed, by some estimates, it may be either slightly higher or slightly lower today than in the past, but there's not actually a huge difference. It is also worth noting that this kind of ignorance is not simply the result of people being stupid or information not being available in the media. Rather, it turns out that for most people, it's actually quite rational to pay little or no attention to political issues, to spend little time and effort acquiring political knowledge, because if you want to, if your only reason to acquire political knowledge is to be a better voter, to choose the right candidate in an election, that turns out not to be much of an incentive at all, given the fact that the chance that your individual vote will determine an electoral outcome, that chance is extremely low, about 1 in 60 million in a presidential election. Even in elections in a small state like Rhode Island, it's probably still maybe 1 chance in 100,000 in a statewide election or something like that. So the incentive is pretty small. Now that gets us to the next aspect of this problem, in that it's not simply a matter of that people acquire relatively little information, it's also that they have poor incentives to do a good job of rationally evaluating the information that they do learn. When I said that there's little incentive to acquire political information, I didn't say that nobody ever had any reason to acquire it at all. Rather, what I said is that the incentive is low if your goal is to be a truth seeker, that is to be a better voter by finding out more about the truth about political issues. But of course, many people have other kinds of motives for acquiring political information. In some cases, you have the motive of acquiring COE credits or other sort of immediate material interests that might be advanced, but more often the goal is that you're simply interested in politics, or you enjoy what I call being a political fan. So for instance, there are many people like me who, in addition to being political fans, are also sports fans. I happen to be a big Boston Red Sox fan. I acquire a lot of knowledge about the Red Sox, as I know many people from Rhode Island also do this. And I don't do so because I want to influence the outcome of Red Sox games or who wins the World Series. I just find it fun to cheer on my team and cheer against that team from New York that cannot be mentioned in polite company, which is the traditional enemy of the Red Sox. So political fans, to some extent, are much the same way. Many of them enjoy cheering on their preferred political party or ideology and hating the opposition. And many of them acquire political knowledge in part to have this enjoyment of cheering on their team, and also to have the experience of having their ideas and beliefs validated by additional information that they bring in. I think this is perfectly fine in a sense. I don't object to people doing this, but if you're acquiring information in large part to get the enjoyment of being a political fan, that means that your motive often is not to seek the truth, and that the way you will evaluate the information is going to be in a very highly biased way. And in fact, many studies that look at the way people evaluate new political information that they learn suggest that they act precisely this way. They tend to overvalue any facts that seem to reinforce their pre-existing views, while undervaluing any new information that goes against them, or indeed discounting it completely. It is also the case that when you look at studies, people tend to read media about politics that it is in alignment with their current views. If you're a conservative, you're much more likely to watch Fox News than if you're a liberal. If you're a liberal, you're much more likely to listen to NPR, read the New York Times. There are many other similar examples. It is also true, by the way, that even just talking informally to people about politics, the evidence suggests that people overwhelmingly do that with people that they agree with politically. If you're a conservative, you tend to talk mostly to conservatives. If you're a liberal, mostly to liberals, and so forth. Now, if people were talking about politics or reading political media primarily for the purpose of seeking the truth, this is not what they would do. As John Stuart Mill famously pointed out, if you're really seeking the truth, you want to understand views opposed to yours, and you are going to realize that people who have opposing views, they're more likely to introduce you to facts and arguments that you haven't heard before than people who have the same view as you do. If, on the other hand, the goal is to be a political fan and to get the enjoyment of being a fan, then this kind of behavior is perfectly understandable. When I attend baseball games, I usually, not always, but I usually try to go with other Red Sox fans rather than with New York Yankees fans, even though I might learn something from the Yankees fans about the culture of that particular evil empire. Nonetheless, my enjoyment will be diminished, perhaps, if I attend a game with Yankees fans rather than Red Sox fans. And similarly, if your goal in acquiring knowledge about politics is to enjoy being a fan of a particular party or ideology, some of the same logic applies. So it turns out that if your goal is not primarily truth-seeking, then it's actually rational to engage in irrational thinking about politics. Economist Brian Kaplan calls this rational irrationality. Now, this does not mean that people deliberately endorse ideas that they know not to be true. I think most people don't do that. It's rather that they don't make much of an effort to logically evaluate the new information they have presented and to try to control their biases. Now, what are the implications of these tendencies for popular constitutionalism? One is, I think, that the combination of ignorance and irrationality and bias suggests that the quality of popular decisions about constitutional issues often will not be very good, and often will be riddled with internal contradictions and other problems that arise at least in part because of ignorance. I'll note a couple of examples from the two movements that I mentioned at the beginning, the Tea Party movement and Occupy Wall Street, of contradictions in their thinking that I think would at least diminish if there was less ignorance and bias. In the Tea Party case, as I think most of you probably know, a central part of their constitutional agenda is to try to limit the powers of the federal government. Thank you. Yet at the same time, many of them, according to surveys, tend to be strong supporters of the war on drugs. Now, if you actually look at some of the key decisions and precedents that have greatly expanded congressional power, the war on drugs is very much at the forefront of that, the leading case being Gonzalez versus Raich, where the Supreme Court said that the Commerce Clause gives Congress the power to forbid the possession of marijuana that had never been sold in any market anywhere and had never crossed state lines. Yet very many of the people in the Tea Party, I think, have not faced up to that contradiction. Similarly, in the Occupy Wall Street movement, as I said before, a key focus of their agenda is the idea that corporations are not people, therefore are not entitled to constitutional rights. At the same time, they're also very strong supporters of legal rights for labor unions. Yet, legally speaking, labor unions are in fact corporations, and indeed the law that was struck down in Citizens United, the decision that OWS loves to hate, among the biggest beneficiaries of that decision were in fact labor unions. If you look at the data on actual spending in electoral campaigns, labor unions usually spend as much or more as commercial profit-making corporations spend. And I think most, if not all, of the OWS people have not faced up to this sort of tension in their position, and I think in part because many of them are simply unaware that this is actually a contradiction there, just as with many of the Tea Party people, they may not be aware of the contradiction in respect to the war on drugs. So I don't think that all of this necessarily proves that popular constitutionalism is a completely terrible idea and that we should leave the Constitution entirely to the courts or other political elites. However, I think it does suggest that our expectations for popular constitutionalism should be tamped down somewhat compared to what they might be if the public were better informed and more logical in their evaluation of new evidence. You might still conclude that we want full-blown popular constitutionalism. If you think that what the elites do or the courts do is really terrible, then maybe even a very ignorant public is still better than that. However, at the very least, the problem of political ignorance should reduce the bar that you would want the elites to clear before you're willing to conclude that judicial review is better than full-blown popular constitutionalism. It's a lower standard of comparison that they would have to meet. Now, despite that, I do think there's a couple of areas where popular constitutionalism can still serve a useful role. One is potentially checking the self-dealing of elites, where the legal elites can try to sort of pursue their own narrow self-interest if they control constitutional law. I think potentially the public can be and sometimes is a check on that. However, political ignorance does reduce their ability to do that because they may simply not know that there's self-dealing going on. A second example is that there are some periods in our history where the legal and political elite has failed in such a spectacular way that even generally ignorant voters can easily understand what is going on and can in effect punish the elite and repudiate their constitutional vision. Probably a really good example of this is the crisis leading up to the Civil War, where I think that the election of Abraham Lincoln in 1860 was in part a result of the very obvious failure of the constitutional vision of the antebellum Supreme Court and Dred Scott, and also other aspects of that elite's approach to slavery and the challenges that it posed. However, most constitutional issues are not as clear-cut and simple as that, and in most cases, it's not as easy to see whether a big disaster is going on, and if one is going on, it's not always easy to tell whether it can be traceable to a specific constitutional vision or not. So on that note, I think it will conclude, and I very much look forward to however much time we have for discussion. Thank you very much.
Thank you, Professor Somin. I do think we should take at least 5 minutes or so to hear some questions, if only because I hate to have the last talk after a whole day of discussion on popular constitutionalism essentially say the people are too stupid. So why don't
Too ignorant, not too stupid.
Sorry, too ignorant. So why don't we hear at least some questions? If you're, I mean, ready to go. Some people probably still have some. Here.
Hi, my question, I don't know if this is on or not, is for mostly Professor NeJaime?
NeJaime?
Yeah, that works. You talked mostly about the marriage cases, but I think there's another line, the DOMA cases, which might have more effect on a lot more things like mini DOMAs. Because I know the Northern District of California, like 2 days ago, ruled it unconstitutional on a summary judgment summary judgment motion. So I was just curious what you or any of the other panelists think with the framing of popular constitutionalism with the DOMA cases as well.
Yeah, so the DOMA cases are interesting because it's a federal litigation strategy that actually didn't take hold until there was a really robust state litigation strategy. So the Perry case, which was the last case I talked about, is really it's a federal lawsuit that was brought against the advice of LGBT rights advocates by a new organization that said, we're not waiting, we're going to file a federal lawsuit seeking to invalidate a state constitutional provision prohibiting marriage for same-sex couples. The DOMA cases were actually brought, the first DOMA case was Gill in Massachusetts, brought by GLAAD, same lawyer from Vermont and Massachusetts, Mary Bonato. Then they filed in Connecticut and New York. Part of the filing of the DOMA cases in New York and Connecticut, which came on the heels of the district court in Massachusetts saying DOMA was unconstitutional, was to put pressure on the Obama administration, part of what Professor Calabresi was talking about, to actually create an opportunity inside the administration to force the administration to move towards a more favorable constitutional position for them. And then the decision that came, so once the Justice Department made its decision saying we're not going to defend DOMA, we think heightened scrutiny should apply and it's unconstitutional, Lambda Legal files a challenge to DOMA on the West Coast, which is the Galinsky case, which a decision came out 2 days ago in which the district court said, we think heightened scrutiny applies, see the Justice Department memo. And if it doesn't, we still think it fails rational basis, just like the Massachusetts court said. And the important thing I think to keep in mind is those cases all rely on states that have already allowed same-sex couples to marry. So it actually is a federal litigation strategy, but it's built on state level advances. So it's leveraging state level advances to move forward the marriage equality agenda, and actually the result would only lead to federal recognition of same-sex couples' marriages in states where same-sex couples are already married, meaning in states where there's already a fairly favorable political environment. Unlike Perry, which if the broader reading that Olson and Boyce were pushing were to prevail, would mean a state like Arkansas, which has no recognition for same-sex couples and a really not very hospitable political environment, would have to allow same-sex couples to marry. So I think the DOMA cases are a great example of the way in which, if we look below the Supreme Court and federal courts, we see that state constitutional provisions in state courts are really important to leverage for federal change.
Any other? Yes.
I'm curious, Professor Swart, have you done any research to determine as between Occupy Wall Street and the Tea Party, which group is actually the most ignorant?
This is a question addressed to me, I assume. So we don't yet have much in the way of good research on Occupy Wall Street. With respect to the Tea Party, there is actually some data which suggests that self-identified Tea Party supporters, that is people who in surveys say they are Tea Party supporters, they actually probably have slightly higher levels of political knowledge than the general public, which arise primarily from the fact that they have slightly higher levels of education and income. Education and income are both predictors of political knowledge. Slightly higher does not necessarily actually mean high, right? So with respect to OWS, I haven't yet seen much in the way of survey data. I suspect that you might get a similar result because in general, people who sort of attend demonstrations and are active and interested in political issues do know somewhat more. So in terms of just pure knowledge, it'll be a little higher. On the other hand, in terms of the other problem that I pointed to, the rational irrationality, sort of biased evaluation of information, that is actually more prevalent among people more interested in politics and more committed to their causes. So for instance, the more interested in politics you are and the more you know, it turns out the more it tends to be the case that you only talk to people of the same views about politics, and the more you're selective you are in terms of the media that you read and so forth. So I think this is sort of an indication of sort of the political fan phenomenon that I was talking about, that the more committed you are to being a political fan, the more sort of intolerant you are of other points of view, like I think actually it's perfectly justified to be intolerant of Yankees fans, but I think that the very committed Red Sox fan on average will be more intolerant of the pro-Yankees perspective than opposed to just sort of a casual Red Sox fan who only is slightly interested in the team.
Any others? Oh, sorry. I can repeat it.
I thought it was fascinating today. I didn't get out of this series of discussions what I expected. We started out with a multi-billionaire senator railing against the influence of money in politics, and we ended with, throughout the day, and then ended with a whole bunch of stories about the influence of money on constitutional jurisprudence. I was actually fascinated by Professor Bogus's story about Rhode Island and that sort of man behind the curtain sort of piece of that story that I hadn't heard before. I'm really directing this to Professor Bogus, but I'd be curious to hear, from any of the panelists, whether it's, Tim Gill's influence on marriage issues in Colorado, or whether it's George Soros or the Koch brothers. What's your take here? Is constitutional jurisprudence really just populist politics, or is there something sort of more substantive to it? It sounds like it's really sort of just a populist movement, like any sort of election or politics.
So, is Jack still here? No. Okay. Well, so I'll channel Jack a little bit because this is probably something he and I think will largely agree on. One of the perhaps minority of constitutional issues will agree, and that is that sort of any movement to change constitutional law in a big way is going to be multidimensional. It will involve some sort of grassroots populist movements. It'll also involve elite organization and funding. There has never been a movement in American history that was at all successful on a major issue that didn't have some elite leadership and funding. That was true of the civil rights movement. It was true of the political movements in the 1930s and so forth. And it's true certainly with the same-sex marriage movement and others. And in terms of whether the courts are simply just responding to public opinion. No, I don't think that's true, entirely true, but it's also the case that both public opinion and elite opinion has an influence on the courts in a wide variety of ways. So the courts are partly independent, but by no means completely so, and their lack of complete independence is, as Steve said, is sort of a design feature of the Constitution. We have judges appointed by a political process, and those judges, therefore, are unlikely to get on the court if they're not, at least to a large extent, acceptable to political elites, and also, to some extent, to general public opinion.
Could I add a point on
Sure.
that? I spoke during my talk about the influence that presidents have in transforming the Supreme Court and the way in which the Supreme Court, to some degree, follows the election returns. But there's a crucial caveat to that, which is that I think the Supreme Court is responsive over time to shifts in elite opinion more than it's responsive over time to shifts in mass public opinion. So, for example, when the school prayer cases were handed down in the 1960s, about 70% of the public thought they were wrongly decided. If you poll people today, there's still large supermajorities who think the school prayer cases are wrongly decided, but that view over 40 years has had a negligible impact on Supreme Court case law interpreting the religion clauses. If anything, the court has expanded beyond the ban on school prayer to banning various religious displays. So I think the court is responsive to changes in elite opinion, but not necessarily to changes in mass public opinion.
Carl, did you want to respond?
Yeah, the other story which I didn't tell you, which is the gun control story, the Second Amendment story. And I can't tell you the story, obviously, but what my experience there leads me to believe that by the time that case had gotten to the Supreme Court, after 40 years of a concerted, and this time I was on the defense, a concerted effort by gun rights forces to change popular opinion as to what the Second Amendment meant. I can tell you, by the way, there was not a law review article that endorsed the individual rights view, or a federal court opinion that endorsed the individual rights view until 1960, when there was one law review article, and the federal courts were unanimous that it was a collective rights view into I don't know, another 30 years past that. By the time it got to the court, it was a done deal, which is why you had 9 justices look at this for the first time, look at the same history, and divide, well, perfectly ideological lines, 5-4. It may have not, had the advocacy groups used different arguments over a different length of time, it may not have had that result. But I actually think there it was over by the time the first brief was filed. And nothing that any advocate said would have made any difference. I'm not saying it's that way in all cases, but in many cases, I fear it is.
All right, I think it's time to call it a day here. I want to thank all of our panelists throughout the day for bringing what I hope was very interesting information. And I want to thank everybody who came.